On 17 August 2022, Mr. Kashi had completed a night's work making deliveries of baked goods. Mr. Kashi was driving towards his home along the Goulburn Valley Highway when the van he was driving drifted into the lane of oncoming traffic and collided with a truck. Fortunately, the truck driver was not injured. Tragically, Mr. Kashi died as a result of the collision. He was 27 years old when he died. The company that employed Mr. Kashi, Onkar Group Proprietary Limited, that I will refer to as Onkar, and the sole director of the company, Mr. Nagy, have pleaded guilty to offences contrary to the Occupational Health and Safety Act, that is, the OHS Act 2004, that I'll refer to as the Act. Onkar has pleaded guilty to 3 charges. Charge 1, recklessly placing a person at a workplace in danger of serious injury. Charge 2, failing to provide and maintain a safe working environment for employees. Charge 3, failing to ensure, so far as was reasonably practicable, that persons other than employees were not exposed to a risk to their health and safety. Mr. Nagy has pleaded guilty to 2 charges. Charge 4 being an officer of a body corporate that contravened Section 21(1) of the Act, where that contravention was attributable to the officer's failure to take reasonable care. Charge 5 being an officer of a body corporate that contravened Section 23(1) of the Act, where that contravention was attributable to the officer's failure to take reasonable care. Circumstances of the offences. The prosecution opening was not disputed and comprehensively describes the circumstances of the offences and the subsequent WorkSafe investigation. At the time of the incident, Onkar operated from a warehouse in Keysborough and employed approximately 30 drivers as subcontractors to collect and deliver baked goods to businesses such as cafes, restaurants and supermarkets across Melbourne and regional Victoria. Onkar provided each driver with a delivery vehicle and directions as to where to make deliveries. Mr. Kashi worked as a contracted delivery driver for Onkar between 10 May 2022 and the date of the collision. On the evening of 16 August and into the following morning of 17 August 2022, Mr. Kashi was driving an overnight delivery route known as the quote, Albury Run. Mr. Kashi had been driving the Albury Run between 1 June 2022 and the 17th of August 2022, the date of the collision. Each of the 5 charges are particularised as having occurred between these dates. Performing the Albury Run would normally require Mr. Kashi to commence work between approximately 11 p.m. and 1:30 a.m. and would require him to drive from his home in St Kilda to a warehouse in Moorabbin to collect items for delivery. Mr. Kashi's first delivery was usually in Oakley South. He would then attend various locations throughout metropolitan Melbourne and regional Victoria on the way to Albury. On his return to Melbourne, Mr. Kashi conducted further deliveries. The number of deliveries when performing the Albury Run varied between 18 to 24. At each location, Mr. Kashi was required to send a WhatsApp message to Onkar with a photograph confirming that the delivery had taken place. The WhatsApp messages were monitored by Mr. Nagy, by Mr. Kumar, an operations manager for Onkar, and Mr. Bhatia, the fleet manager for Onkar. Mr. Kashi's final delivery would usually be in Shepparton, although sometimes his last delivery was in Benalla. On the morning of the fatal collision, Mr. Kashi was driving a van supplied by Onkar. His first delivery was in Oakley South at 12:39 a.m. and his last delivery was just over 12 hours later at 12:40 p.m. in Shepparton. Shortly after his last delivery, Mr. Kashi was driving the van in the southbound lane of a 100 km/h zone on the Goulburn Valley Highway, Kialla West. A truck carrying 2 empty shipping containers was travelling in the opposite direction in the northbound lane. Weather conditions were good and visibility was clear. Dashcam footage from the chuck shows that Mr Kashi's van veered from the southbound lane across solid double white lines and into the northbound lane. The truck moved to the left, attempting to avoid the collision. The van disappears from the dashcam footage moments before it collided with the driver's door and containers on the truck. Onkar became aware of the incident on 18 August 2022. Mr Nagy was overseas in the USA on the date of the fatal collision. The total estimated driving distance of the Albury Run is 796 kilometres. The total estimated driving time is approximately 10 hours and 54 minutes. This estimated driving time does not include the time it would take to stop at the delivery locations and deliver the goods, or the time driving before the first delivery and the time driving home after the last delivery. When Mr Kashi commenced work with Onkar, he was provided with on-the-job training conducted by the fleet manager, Mr Bhatia. As part of the training, he was told, quote, to take rests every 2 hours and to leave the steering wheel. Mr Bhatia told investigators that, quote, there was no set times for breaks, but he told Mr Kashi to, quote, take 20 to 30 minutes each time. Mr Kashi's, quote, training feedback report states Mr Kashi was provided with induction training by Mr Bhatia on 10 May 2022. This included information about safe driving and fatigue management under the heading Trainer's Feedback. Mr Bhatia wrote an entry stating, Rahula Kashi is a safe driver on the road and follow all the road rules. He is never rushing to finish his task on time. He feels a little bit difficulty with organising the deliveries, but in my opinion, this can be improved with experience and time. Mr Kashi signed a, quote, subcontractor contract with Onkar dated 26 May 2022. Mr Nagy signed the contract on behalf of Onkar. The contract contained a section titled Subcontractor Delivery Driver Break Time Policy, which stated, subcontractor drivers are advised to take a 30-minute break during their scheduled shift whenever they deem fit. This is Baecology's recommendation along with the transport laws in Vic. This break must occur after 3.5 hours into the shift and prior to 5.5 hours after the fixed start time of some subcontractor drivers' ordinary hours of work. Breaks must be taken in a safe location wherever the subcontractor drivers desire along their route. If fatigued, subcontractor drivers are implored to take a 5-minute refresher break during their shift for road safety practices. This break time policy was included in the contracts between Onkar and all of its contracted delivery drivers, save and except for 4 contracts that were signed in a period of time before Mr Kashi commenced work with Onkar, and to which I will make further reference later in these reasons. Mr Kashi's contract provided that he was to be paid a daily minimum fee of $350. A WorkSafe investigation conducted after the fatal incident obtained documents which included WhatsApp messages from 1 July 2022 to 17 August 2022 from Mr Kashi to Onkar, including photographs of deliveries and phone records of Mr Kashi between 1 May 2022 and 18 August 2022. On the second day of the plea hearing, the prosecution tendered a table that summarises the WhatsApp messages sent by Mr Kashi to Onkar between 1 July and 17 August 2022. The last column of the table estimates the driving time, excluding the period of driving before the first and last delivery. Mr. Kashi worked during these dates. WorkSafe engaged 2 experts to express opinions regarding Mr. Kashi's schedule of work and the likely level of fatigue he would have experienced driving the Albury run. These opinions were not challenged. WorkSafe Inspector Tan, a senior psychological health and safety specialist and registered psychologist, was one of the experts. The other was Professor Dawson, who has a doctorate in psychology and is the director of the Centre for Sleep Research at the University of Adelaide. Inspector Tan used fatigue assessment software by Interdynamics, that I will refer to as FAID or FAID. He entered data based upon the WhatsApp messages sent by Mr. Kashi, which were time-stamped and correlated with deliveries over the days leading up to the day of the collision. The analysis showed from 9 July 22 to 17 August 22, a large proportion, at least 5 hours of every presumed work shift, as indicated by the WhatsApp timestamps linked to the proof of delivery messages, posed an increased risk of fatigue. The increased risk of fatigue was represented by FAID scores of above 80. On 16 August 2022, the entire presumed work shift, 11 hours 30 minutes, posed an increased risk of fatigue with a peak FAID score of 142. FAID scores between 80 and 100 are equivalent to the predicted level of work-related fatigue achieved after 21 to 24 hours of continuous sleep deprivation. Performance impairment at such a level of sleep deprivation is comparable to that experienced at a blood alcohol concentration over 0.05%. Inspector Tan expressed the view that operating a vehicle with impaired performance can lead to slower reaction times and or lapses in attention, which in turn increase the risk of serious injury or death. Inspector Tan also expressed the view that the roster characteristics and reliance on drivers to monitor fatigue represented a failure of Onkar's system of work to assess and control the risk of fatigue so far as was reasonably practicable. Professor Dawson was provided with a list of, quote, first and last delivery times for Mr. Kashi based on the WhatsApp delivery confirmation photos from the period between 1 July and 17 August 2022. He noted that these likely underestimated Mr. Kashi's working times as they excluded his commute to and from home, the drive to collect his load, and the drive to his first delivery location. It became apparent during the plea that there was an error in some of the data provided to Professor Dawson. The data supplied suggested Mr. Kashi did not work on 31 July 2022, whereas phone records suggest he did work that day. While Professor Dawson was of the opinion it was difficult to determine the likely level of Mr. Kashi's fatigue at the time of the collision, he utilised the FAID software and expressed the opinion that between 1 July 2022 and 17 August 2022, Mr. Kashi likely experienced an estimated average level of fatigue-related impairment greater than 0.05% blood alcohol content for more than 90% of his hours on the road. Based on the ISO 310 likelihood, that is the International Organisation for Standardisation scale, Professor Dawson expressed the opinion that fatigue-related error was, quote, almost certain for the majority of the hours Mr. Kashi worked in the week prior to the incident. Using the Karolinska Sleepiness Scale and a computer simulation, he expressed the view that Mr. Kashi's fatigue levels were described as being level 8 sleepy, some effort to stay awake, or 9, very sleepy, great effort to stay awake, fighting sleep, for most of Mr. Kashi's time driving. In Professor Dawson's opinion, the working time arrangement would carry a very high likelihood of fatigue-related error, and the consequences of such an error is extremely severe. He opined that Onkar's system of work was entirely inadequate with respect to managing the risks associated with driving while fatigued, and that the shift pattern and roster was, quote, at best an onerous schedule that fails completely to provide an employee with sufficient time to sleep, rest and recover in order to return fit for work. Professor Dawson expressed the view that the training and education provided by Onkar was, quote, manifestly inadequate and scientifically inaccurate, that further information was required to be provided to drivers as to how to identify and manage fatigue. He identified freely available guidance material, some of which is published online by WorkSafe Victoria, Safe Work Australia, and the National Heavy Vehicle Regulator, that is NHVR, which could be located using a simple Google search. It was not in dispute that these NHVR guidelines are designed for heavy vehicles and do not regulate the driving of the van driven by Mr. Kashi. Nevertheless, Professor Dawson expressed the opinion that these recommendations, quote, provide clear guidance to those involved in the transport task, and these guidelines are often adopted by companies looking to establish a performance benchmark for their risk assessment mitigation process. The WorkSafe investigation determined that between October 2021 and February 2022, Onkar entered into 4 contracts with delivery drivers that incorporated the NHVR 2022 guidelines. Those contracts included the following provision. Subcontractors act as solo drivers and are responsible for taking breaks when they please during their shifted work. We advise subcontractors to follow the below safety, accreditation and compliance fatigue management from the National Vehicle Regulator, NHVR 2022. A table is then promulgated by the body that has a column, and I won't read the whole table, but it basically has a driving hours, the time of driving and the recommended rest breaks for periods of time of driving of 5.5 hours, 8 hours, 11 hours, 24 hours, over 7 days and over 14 days. I might indicate that over 7 days, the final column recommends 24 continuous hours of stationary rest time and over 14 days, 2 night rest breaks and 2 night rest breaks taken on consecutive days. Mr. Nagy signed each driver contract on behalf of Onkar that included the above policy, which is a direct extract of the NHVR standard hours. There was no evidence presented during the plea hearing that shed any light on why these guidelines appeared in only 4 contracts Onkar entered into with contracted drivers in a period of time before Mr. Kashi was employed, but were not included in any other contracts signed after February 2022 and not in the contract signed with Mr. Kashi. As part of WorkSafe's investigation, statements were obtained from former and current drivers employed by Onkar and Mr. Kumar and Mr. Bhatia. Mr. Kumar was Mr. Kashi's direct manager. He stated that on one occasion he told Mr. Kashi he needed to take a break. In response, Mr. Kashi told him, quote, "It is okay, I do not need a break as I have my friend." Mr. Kumar saw a friend with Mr. Kashi on one occasion. Mr. Bhatia also states that before the collision, Mr. Nagy and Mr. Kumar were responsible for the fatigue management of drivers, but after the incident, Mr. Bhatia performs this task on his own. Mr. Bhatia states he observed Mr. Kashi with a friend on 2 occasions, but he did not know who the friend was. Mr. Madhav was a former driver at Onkar. Over a 2-year period, he completed the Albury Run 6 days a week. He states the Albury Run would take between 14 to 16 hours, included 25 deliveries, and if he took a break, he would be late for deliveries. He states that Mr. Nagy would tell him to rest at night and make sure he slept between delivery days. Mr. Madhav states he used to get very tired and remembers, quote, many times falling asleep at the wheel, especially in winter when he would turn the heater up. He states that he told Mr. Nagy, quote, I wanted to do 4 days as I was always tired, but Mr. Nagy responded that there was no one else to do the run on the other days. In 2020 or 2021, Mr. Madhav reduced his work hours and stopped doing the Albury Run. A former operations manager and driver with Onkar, Mr. Onkar, left the role of operations manager in March 2022. He stated that he was provided with templates by Mr. Nagy to make, quote, run sheets for drivers for each route. He regularly worked 14-hour shifts and there were no rules around rest and fatigue. On one occasion, when he was completing the Albury Run, he was tired and pulled over and fell asleep for 4 hours. Another driver, Mr. Jasti, was employed by Onkar between 2020 and 2022. He drove a route that would take between 12 to 13 hours and he used to get very tired. He recalled instances of falling asleep when driving and waking when he hit lines on the road. He stated that he told Mr. Nagy about these incidents and Mr. Nagy would offer to increase his pay but would not shorten the run. Mr. Jasti states on one occasion he fell asleep while driving and his vehicle hit railings in the middle of the road. The vehicle was not extensively damaged. Mr. Jasti took a rest, and as he was worried he would be charged an insurance excess by Onkar if he reported the details of the incident, he reported the damage as involving a kangaroo. The prosecution relies upon these interviews with drivers and staff as evidence of Onkar and Mr. Nagy's knowledge of the risks associated with subcontractors driving while fatigued, the length of time required to complete the Albury Run, the inadequacies of the company's systems of work, and the inadequate training provided to delivery drivers. After the incident on 17 August 2022, 2 drivers shared the driving for the Albury Run. Mr. Gali was employed by Onkar in January 2023 and performs the Albury Run 2 days a week. He was trained to do the Albury Run with another driver. They take breaks regularly, at least every 3 hours. WorkSafe inspectors issued improvement notices to Onkar after the fatal incident. The first notice was issued on 10 October 2022. The notice required a detailed fatigue management policy to be implemented by Onkar. Onkar were referred to guidance materials from the National Heavy Vehicle Regulator, including standard hours and driver work diary requirements. A WorkSafe inspector attended Onkar on 12 December 2022 and observed that while the GPS vehicle tracking management program had been installed in Onkar vehicles, there were some deficiencies in monitoring the program. Compliance with the first notice was not regarded as satisfactory. On 15 December 2022, the inspector re-attended Onkar. Both he and Mr. Bhatia contacted drivers completing regional delivery runs. All drivers conveyed that they were aware of requirements for rest breaks and were complying with the requirements. As a result, the company was deemed to have complied with the first notice. On 9 March 2023, a further inspection at Onkar revealed the GPS monitoring system was not available for the Albury run, and it was apparent the company could not monitor if appropriate rest breaks were being taken by drivers. A second improvement notice was issued. On 17 April 2023, a further inspection at Onkar revealed that the situation was rectified. The GPS tracking of vehicles on the Albury run was working effectively. WorkSafe declared compliance with the second notice. Legal principles and objective gravity of the offences. The legal principles applicable to OHS offences are not in dispute. General deterrence will normally assume considerable significance and is a consideration of great importance. The objective seriousness of the offending is the primary factor in determining the appropriate sentence. Subjective factors pertaining to the accused, such as a plea of guilty, financial circumstances, remedial measures to improve safety, while relevant and must be taken into account, play a subsidiary role in determining what is a just and appropriate penalty. Charge 1 is the most serious charge faced by Onkar. It is a breach of Section 32 of the Act. It involves recklessly engaging in conduct that places or may place another person in danger of serious injury. It is regarded by definition, as well as by express intent, as a high culpability offence. In orbit drilling, the Court of Appeal stated that a Section 32 offence is different from other offences under the Act, which are offences of absolute liability. A Section 32 offence calls for rules of attribution. It's necessary to identify the persons whose recklessness is to be attributed to the company for this purpose. The court stated the degree of culpability of an offender who contravenes Section 32 will depend on what is established regarding the offender's awareness of, first, the degree of probability that the worker would be placed in danger of serious injury, and secondly, the nature of the probable danger thus foreseen. As the offending involves foresight of the probable consequences, closer attention is usually paid to the actual consequences of the offence. The Court of Appeal has observed where the employer's reckless conduct does cause actual harm, the extent of the harm might be thought to be relevant to penalty, at least where what occurred was within the scope of the danger foreseen. It might be said, for example, that the reckless exposure of an employee to risk would be viewed more seriously when it resulted in the employee's death than when it resulted in serious injury. As the foresight in this case is related to driving at speeds associated with travelling in rural Victoria while fatigued, it would be difficult to contend that what occurred, namely a serious collision causing death, was outside of the scope of the danger foreseen. Samaya Kashi, Mr. Kashi's wife, made a victim impact statement in which she poignantly describes the devastating consequences of the death of Mr. Kashi. Rohila, that is, Mr. Kashi, was not just my husband, he was my partner, my protector, and the foundation of our family. He was a kind, hard-working and selfless man who dedicated his life to providing for those he loved. He carried the heavy responsibility of supporting not only me, but also his mother and sisters, ensuring that we had a home, food, and the hope of a better future. He was the heart of our family, and without him, we are lost. She describes her grief as, quote, unbearable. She's now struggling to survive in Afghanistan, where she and Mr. Kashi's mother and sisters are in a desperate financial situation. She describes their futures as, quote, uncertain and frightening. It must be said that no fine imposed by this court can or should be regarded as in any way a measure of the value of the life of Mr. Kashi. However, it is simply the fact that the court, pursuant to this section, places closer attention to the consequences of the offence, and the death of Mr. Kashi is a tragic consequence of this offending. Charge 2 and 3 against Onkar and charges 4 and 5 against Mr. Nagy are risk-based rather than outcome-based offences. Emphasis is placed upon the failure to adequately address the risk. In relation to charge 2 to 5, I must be conscious of the following sentencing principles. The gravity of a contravention is determined by two factors: the seriousness of the breach, that is, the degree of departure from the duty, and the extent of the risk resulting from the breach. The second of these factors, the extent of the risk, is a product of two further factors: the likelihood of the occurrence of an endangering event as a result of the breach and the potential gravity of the consequences of that event. Charge 2 against Onkar is based upon the company's failure to maintain a safe working environment for employees. It also incorporates the failures relating to training and the failure to provide sufficient information designed to minimise the risks to health and safety. Charge 3 against Onkar relates to the same deficiencies as expressed in charge 2, but in relation to the risks posed to road users other than employees of Onkar who may have been at risk due to Mr. Kashi's driving. Charges 4 and 5 are the same contraventions as charge 2 and 3, but are against Mr. Nagy personally. The charges are pursuant to section 144 of the Act, which states that an offence is committed in circumstances where a contravention of the Act is attributable to an officer of the company failing to take reasonable care. The prosecution has referred me to a number of comparable cases, with the concession that none of the cases referred to are directly comparable to this case. 3 of the cases involve breaches of section 32 of the Act. The cases provide some limited assistance, but also exemplify the range of factors that might be relevant in evaluating the objective gravity of a particular offending. Dennis Jones Engineering involved an apprentice being directed to steady a pipe in a lathe in circumstances where it was known by the employer that such a practice, given the length of the pipe, was dangerous. The prosecution submits that a distinguishing feature is that the offending occurred on a single date, whereas in this case the offending continued over a protracted period of time. The company was fined the equivalent of approximately 58% of the maximum penalty. Although the case did not involve a death, the injuries suffered by the victim were catastrophic. In Bedford, the county court decision, a company director personally instructed unqualified divers to perform commercial diving tasks in circumstances where regulations were breached. The divers were not properly trained, and the divers were provided with inadequate equipment. The prosecution distinguished this case on the basis that nobody was injured or killed. The learned sentencing judge imposed fines that were only a small percentage of the maximum penalties. There were a number of Section 32 offences, as there were a number of divers, and it appears the amount of the fines imposed were tempered by considerations of totality. In the case of orbit drilling involved an inexperienced and untrained worker being directed to drive a heavily loaded truck with defective brakes down a steep slope. The truck had been poorly maintained, and the records relating to the maintenance of the truck should have alerted the company to the risk that the brakes were possibly defective. The worker died as a result of losing control of the truck. The fine imposed equated to 77.5% of the maximum penalty. However, the Court of Appeal made comments regarding the inadequacy of the maximum penalty at that time. The maximum penalty for a breach of Section 32 has been significantly increased since orbit drilling was decided. The other cases referred to by the prosecution related to county court decisions in respect of breaches of Section 23 and Section 21 of the Act. They relate to two companies being sentenced in respect of the same incident involving a driver of a roadside assist vehicle working for such a long and continuous period that he suffered a fatal accident as a result of fatigue. The prosecution submits that the objective seriousness of the offending by Onkar is greater because these cases do not involve recklessness and the contravention occurred over a shorter period of time. I accept that one of the aggravating features of this offence is the number of days Onkar engaged Mr. Karshi to perform the Albury run. However, in my view, there are aggravating features in the cases referred to by the prosecution that do not feature as predominantly in this case. In the three cases regarding the breach of Section 32, the victims were particularly vulnerable in that they were not able to appreciate the dangers to which they were being exposed, or realistically what actions they could have taken to moderate the risk. For example, in Dennis Jones, the victim was a second-year apprentice. For example, in Dennis Jones, the victim was a second-year apprentice who had not previously worked with the longer pipes that were more dangerous when placed in the lathe. He was directed to perform the dangerous task by the director of the company who was present, taking part in the activity himself, and who had many years' experience. The employer had personal knowledge of the risk by witnessing a longer pipe breaking off years before. One could hardly expect a second-year apprentice in these circumstances to appreciate the risk he was exposed to, or realistically, how he might take steps to minimise the risk. Similarly, in orbit drilling, the victim was an inexperienced 21-year-old who had no knowledge of the requirements for proper training to perform the task he was directed to perform, or the fact that the brakes on the truck he was asked to drive were defective. Again, he was being directed to perform the dangerous task by someone who was present who held a superior managerial position. It was practically difficult for the driver to take any action to minimise the risk other than an outright refusal to perform the task. In Bedford, inexperienced and untrained divers were directed to perform the task that placed them at risk by the owner of the company, who was a qualified commercial diver with specialised knowledge. The victims relied upon what they believed was the specialised knowledge of the employer, who was present and directing them to perform their work. They were sometimes reassured and implored by the employer to continue with their dangerous work despite their reservations and inadequate equipment. In my view, a relevant distinguishing feature in the case against Onkar is that the risk of fatigue when driving is a risk that is commonly understood within the community. To some extent, a driver is best placed to monitor their own levels of fatigue. It is also common knowledge that the best way to manage the risk of fatigue is to take a break. This is something that is easier for a driver to do when driving on his own than the actions required to alleviate the risks in the Section 32 cases referred to by the prosecution. When I raised these distinguishing features of the case with the prosecutor, Ms. Argyropoulos, she did not submit that the above observations were irrelevant to the assessment of objective gravity of the offending. However, she relied upon provisions of the Act that subcontractors are to be regarded as employees. She also referred me to cases, although not specifically concerning a breach of Section 32, involve consideration of how the Act places obligations on employers to be proactive in minimising the risks to health and safety of employees. I found comments of Justice Harper in Holmes to be particularly apposite to the circumstances of this case. In considering a breach of Section 21 of the Act, His Honour stated, The Act does not require employers to ensure that accidents never happen. It requires them to take such steps as are practical to provide and maintain a safe environment. The courts will best assist the attainment of this end by looking at the facts of each case as practical people would look at them, not with the benefit of hindsight, nor with the wisdom of Solomon, but nevertheless remembering that one of the chief responsibilities of all employers is the safety of those who work for them. Remembering also that in the main, such a responsibility can only be discharged by taking an active, imaginative and flexible approach to the potential dangers in the knowledge that human frailty is an ever-present reality. Although these comments were made in relation to Section 21 of the Act, they are, in my view, applicable when considering the recklessness in this case. The expert evidence provides a detailed analysis of the risk Mr. Kashi was exposed to by driving the Albury Run for such long hours, for so many consecutive days. However, as acknowledged by the plea, Onkar did not need to be aware of this detailed analysis to have foresight of the risks of driving fatigued associated with such a schedule. The company had previously incorporated into their contracts their NHVR guidelines that recommended a safe schedule of rest breaks required when driving for prolonged periods. Although no data has been presented for the work schedule Mr. Kashi performed when driving the Albury Run in June 22, the WhatsApp messages and phone records reveal Onkar engaged Mr. Kashi to drive the Albury Run over approximately 7 weeks without the recommended days off to rest. The company did not need to be aware of expert analysis to appreciate that Mr. Kashi was being engaged to perform a work schedule that was both gruelling and dangerous. The prosecutor submitted that it was open to the court to impose an aggregate sentence in respect of charges 2 and 3 against the company and an aggregate sentence on charges 4 and 5 against Mr. Nagy. This is because the conduct substantiating charges 2 and 3 and the conduct substantiating charges 4 and 5 is the same. The reason there are 2 charges relating to the same conduct is that the consequences of the conduct pose risks to different people. In the case of charge 2 and 4, employees, and in the case of 3 and 5 persons other than employees. I accept that submission and intend to adopt that course. The prosecution also submitted that in relation to the aggregate sentence imposed in respect of charges 4 and 5, it would be open to the court to impose a community corrections order on Mr. Nagy. As mentioned above, Mr. Nagy is the sole director of the Onkar company. In this sense, the fines imposed upon the company will adversely impact upon Mr. Nagy personally. It's not in dispute that this is a relevant factor to which I must have regard. This is an important consideration when applying the principle of totality. The principle requires that although each charge is to be considered separately, I must not lose sight of the total amount of the fines imposed in respect of the totality of the offending, and that the fines imposed on the company will also have an impact upon Mr. Nagy. I might observe that in relation to imposing an aggregate penalty in respect of charges 2 and 3, I am of the view that there is a greater overlap between charge 1 and charge 2 than between charge 1 and charge 3. Although charge 2 involves particulars of conduct relating to the failure to provide adequate safeguards, training and information to employees that are not elements of charge 1, it's difficult to envisage how a company might be guilty of charge 1 in circumstances where the person placed in danger was an employee without also being guilty of charge 2. Charge 3, on the other hand, relates to the risk posed to persons other than employees. The prosecution also submitted it was appropriate to make an adverse publicity order pursuant to section 135 of the Act. Initially, Mr Connors, on behalf of Onkar, submitted that an adverse publicity order should not be imposed. He ultimately withdrew that submission and instead submitted that an adverse publicity order should be regarded as part of the punishment imposed upon the company and be taken into account in applying the totality principle. I accept that submission. Defence submissions and factors in mitigation. Neither Mr Connors on behalf of the company nor Ms Edwards on behalf of Mr Nagy made detailed submissions regarding the objective gravity of the offences. Mr Connors made the point that the contract signed by Mr Kashi did allow his deliveries to be conducted by a third party. However, this point was not pursued as being of significance in evaluating the objective gravity of the offending. It was not submitted that the company believed that anyone other than Mr Kashi was driving the Albury run during the period of the charges. The undisputed summary and particulars of the charge are based upon Mr Kashi being the person who performed the driving over the period of the charges. Mr Connors, on behalf of the company, submitted that the company was a family business that had since its inception in 2009 grown from a single van delivery operation to a commercial scale enterprise servicing over 150 delivery points. The company was, in the sense that the term can apply to a company, of previous good character. Further, the company had demonstrated remorse by pleading guilty at an early stage and, consistent with its good character, cooperated fully with WorkSafe. Although, as described above, there were some initial failures to comply with the improvement notices, the company had, after a relatively short period of time, comprehensively rectified the risks related to fatigue. The company had spent over $100,000 in installing a GPS monitoring system that enabled it to monitor drivers' compliance with mandated risk brakes. It had engaged managerial personnel to oversee daily safety compliance and instituted mandatory declarations required of drivers and driver diaries, which required drivers to demonstrate their compliance with required rest breaks. Mr Connors' written submissions detail the various procedures put in place since the incident that he submitted, quote, represent a permanent shift in the company's approach to safety, risk management and accountability. Letters were tendered from people who had worked for the company or who had an association with the company. These letters described the company as diligent concerning workplace safety. These letters suggested this offending was inconsistent with the previous good character of the company. Mr Connors also tendered the financial statements of the company for the years ending in 2021, 2022 and 2023 in a letter from an accountant, Mr Cheaton Relay, who had provided accounting services to Onkar and Mr Nagy for 13 years. The letter states that the financial position of the company was commercially sound at the time of the incident, but that currently the company is not commercially sound with several debts and liabilities. The financial statements recorded that at the end of the financial year in 2021, profit was recorded as $860,765, whereas at the end of the financial year in 2023, it was $37,332. Mr Connors submitted that Mr Nagy has for several months deferred his own income and directed all financial resources to maintain staff payments and cover supplier costs. Mr Connors' written submission states, a significant monetary penalty would almost certainly push the company into insolvency. This would not only result in the loss of livelihood for over 40 subcontractors and their families, but would also compromise the long-term implementation of improved safety systems. A modest fine is respectfully submitted as being the only penalty consistent with the company's financial realities and the principle of proportionality. A fine of $20,000 would be half the annual operating profit for the last annual return. Counsel for Mr Nagy, Miss Edwards, emphasised Mr Nagy's previous good character. She relied upon his early plea of guilty and remorse. Many of the details of Mr Nagy's background and his reaction to the incident are described in a psychological report of Mr Geoffrey Cummins. Mr Nagy is 49 years old and was born in New Delhi. He finished Year 12 and completed a diploma in computer science in India. He married at the age of 22 and has 2 daughters. The family migrated to Australia via a skilled visa program in 2006. The family members became Australian citizens in 2008. Miss Edwards described Mr Nagy's personal background as a very successful, quote, migrant experience. He was 30 years old when he came to Australia. He purchased in partnership a news agency in Footscray, which he operated for 3 years while also working as an owner-driver for a bakery. He built up his own bread delivery business through hard work and ultimately became the director of Onkar, which now manages 40 delivery vehicles. Mr Cummins gave evidence during the plea hearing and expanded on the matters he had detailed in his report. After administering a number of psychological tests on Mr Nagy and discussing the impact of the incident, Mr Cummins wrote in his report, "In my opinion, Mr Nagy is now diagnosed with a major depressive disorder, which is severe in type and complex PTSD. Mr Nagy's eldest daughter, aged 26, has been undertaking tertiary studies for 2.5 years but left her course to work for Onkar in an administrative role as a result of this incident." Mr Cummins' report states, "Mr Nagy's mental health has deteriorated very significantly as a result of the subcontracted employee's death in the accident on 17 August 2022, and as a consequence, Mr Nagy has no longer been able to manage his business as thoroughly as he was able to do prior to the accident. And as a consequence, he has now employed one of his daughters, a manager, a fleet manager, and 2 supervisors." Tendered on behalf of Mr Nagy were a number of character references that describe him as deeply remorseful and as a caring and supportive individual. Each reference attested to his devotion to his family, hard work ethic and integrity. Both the report of Mr Cummins and a letter from Mr Nagy's general practitioner describe him as suffering from type 2 diabetes as well as anxiety and stress-related conditions. He is receiving medication for some of these conditions. Like Mr Connors on behalf of Onkar, Miss Edwards emphasised how Mr Nagy had responded to the offending by ensuring that there are now very strict safety measures in place that monitor drivers' compliance with requirements to manage their fatigue. In relation to Mr Nagy's financial circumstances, Miss Edwards tendered Australian Taxation Office Notice of Assessment documents for the years ending 2021, 2022 and 2023. These documents demonstrated a relatively modest taxable income over those years. Reliance was also placed on the accountant's letter referred to above that states Mr Nagy does not have personal assets but for 2 properties as part of a venture agreement. He also has personal loans and a tax debit amounting in total to $55,000. Miss Edwards submitted that the court should not impose a conviction on Mr Nagy. She raised a concern regarding the psychological impact of a conviction upon Mr Nagy and also the effect a conviction might have on his ability to be a director of a company. She submitted that a conviction may prevent him from being able to travel to the USA to visit his mother and siblings. It was not in dispute that Mr Nagy's father had passed away in the USA shortly after the incident, the subject of these proceedings, and that Mr Nagy's mother, who is aged 68, has recently undergone open heart surgery. She also submitted that in all the circumstances it would be inappropriate to impose a community corrections order, as Mr Nagy would suffer great embarrassment by the imposition of such an order and a degree of shame. Miss Edwards, like Mr Connors, submits Onkar operates on narrow margins, servicing multiple contractors, subcontractors whose livelihoods depend on its continuation. Further, Mr. Nagy has not drawn substantial personal profit from the business and his family remains financially dependent upon him. She submits only a modest fine as appropriate in the circumstances. During the hearing, the prosecutor conceded that a plea on behalf of both Onkar and Mr. Nagy should be regarded as entered at an early stage. It was also conceded that the character references and psychological report were consistent with Mr. Nagy being remorseful, and that the delay between the incident and the matter being finalised was likely to have exacerbated Mr. Nagy's mental health problems since the incident. Further, it was conceded that while there was a short period of non-compliance with the improvement notices, there has been very effective remedial action taken by the company and Mr. Nagy that reduced the ongoing risk. Given the remedial action and prior good character of Onkar and Mr. Nagy, specific deterrence might be regarded as being of little weight. I accept these concessions. I have taken these factors into account in moderating the fines to be imposed. The prosecutor submitted the material and submissions on behalf of Onkar and Mr. Nagy's financial position was not completely clear regarding their ability to pay a fine. It was pointed out that over the 3 years from 2021 to 2023, to which the financial statements related, the income of the company appeared to increase from 3.1 million to 5.1 million, but because of expenses, the profit of the company was less. Further, the expenses of the company were not completely transparent, and the documentation demonstrated that the company owned fairly substantial assets. The most recent financial statements recorded $320,000 as cash in the bank, and the accountant's letter suggested that while the company is at present not commercially sound, Mr. Nagy should, quote, refinance his entire fleet and take out a business loan. In relation to Mr. Nagy's personal financial position, it was submitted there was also a degree of uncertainty. The notice of assessments only related to taxable income, and there is no description of the actual value of the 2 properties held by Mr. Nagy as part of a venture agreement. Further, it was submitted that arrangements can potentially be made for a fine to be paid over time by instalments. As I understood the submission, it was that while the defendants had submitted correctly that the court must take into account, as far as practicable, the financial circumstances of the offender and the nature of the burden that its payment will impose, it was unclear whether a fine that properly reflected the objective gravity of the offending would allow the company to continue to trade. The prosecutor referred to recent authority that reinforced the principle that general deterrence is the predominant sentencing consideration and an offender's capacity to pay cannot result in the imposition of a fine that fails to reflect the objective seriousness of the offence or the need for general deterrence. In relation to Mr. Nagy, it was submitted that the circumstances of the offending were too serious to result in a penalty without conviction, and the evidence was speculative as to whether a conviction as opposed to a finding of guilt would result in Mr. Nagy being able to travel to the USA or result in him being unable to act as a director of a company. In relation to the option of a CCO on charges 4 and 5, it was pointed out that Mr. Cummins' evidence was that Mr. Nagy would benefit from ongoing counselling. Further, that while the company currently employed numerous staff, the authorities did not suggest that was a relevant consideration that could be taken into account when considering what was a just and proportionate sentence. I accept that Mr. Nagy personally has been deeply affected by this tragedy. He is a person of previous good character. He's built up through hard work a company that provides a valuable service and provides employment for a number of people. Mr. Nagy is genuinely remorseful. Significant time and expense has been saved by early pleas of guilty, and there's been an unfortunate delay that has no doubt exacerbated the anxiety and strain Mr. Nagy has had to deal with until this matter is finalised. Both he and the company are to be commended for reacting to this tragedy by putting in place a sophisticated electronic monitoring system that ensures drivers take appropriate rests. I also accept that since the incident, and partly because of the incident, the company has lost business and is financially struggling. I have taken into account these matters and the material relating to the financial circumstances of the company and Mr. Nagy by moderating the fines I impose. However, as I pointed out to Mr. Commoners during the plea, to impose a modest fine, quote, proportionate to the company's current operating capacity, end of quote, on the basis the company's annual profit is $40,000 would not reflect the objective gravity of the offending. In relation to the adverse publicity order, this case, unlike many other cases involving breaches of OHS provisions, posed a significant risk to the safety of members of the public. It also, according to the report of Mr. Cummins, involved a misunderstanding on the part of Mr. Nagy. Mr. Nagy told Mr. Cummins, quote, well, he was a subcontractor, and I always thought it was his responsibility to manage issues to do with fatigue. An adverse publicity order should be imposed in the hope that it will promote general deterrence and educate employers of subcontractor drivers that they must not abdicate their responsibility to manage issues relating to fatigue. I accept the prosecution's submission that charges 4 and 5 are too serious to allow penalty without conviction. The offending period is prolonged. The statements and other drivers working for Onkar provide evidence that the company and Mr. Nagy failed to respond appropriately to issues regarding fatigue. Mr. Cummins gave evidence that as a result of assessing Mr. Nagy, he ascertained that leading up to the incident, Mr. Nagy was concerned about issues of fatigue for drivers because they were matters that had been raised. Mr. Nagy was aware of the NPHR guidelines as he had signed contracts that previously included those guidelines. Mr. Kashi was engaged on a work schedule that breached those guidelines in a number of different respects. I am also not satisfied on the balance of probabilities. A conviction as opposed to a finding of guilt will necessarily change Mr. Nagy's ability to travel to the USA or his ability to be a director of a company in the future. No evidence was tendered in support of that submission. However, even if I was so satisfied, the seriousness of the offences committed by Mr. Nagy must result in a conviction. Given the objective gravity of the offending and the primacy of general deterrence as a sentencing consideration, I must impose fines in an amount that, given the material before me, it is unclear whether the company will be able to continue to trade. I accept the prosecution's submission that I cannot have regard to the consequences that flow to other current employees of the company should that be the case. Since the plea hearing was conducted, I've had Mr. Nagy assessed as to his suitability to undertake a CCO. The assessment indicated that Mr. Nagy is already engaging with mental health services in the community and that he's working on a full-time basis. Given his instructions to Mr. Edwards that he's reluctant to be placed on such an order and the limited weight to be attached to specific deterrence, I have decided to impose an aggregate fine in respect of charges 4 and 5. Balancing as best I can the various sentencing considerations in this case and having regard to the material placed before me, the submissions of the parties and all relevant matters, I impose the following sentence. In respect of charge 1, Onkar is convicted and fined the amount of $1,100,000. On charges 2 and 3, Onkar is convicted and fined an aggregate amount of $250,000. On charge 4 and 5, Mr. Nagy is convicted and fined an aggregate amount of $80,000. Pursuant to section 135 of the Act, I order that Onkar must publicise a one-off, full-page advertisement in Owner-Driver magazine that details the offending and penalties imposed consistent with Schedule 1 attached to these reasons. Further, pursuant to section 1351B of the Act, the terms of this order are to be actioned before 28 February 2026, and Onkar is to provide the Victorian Work Cover Authority by the same date written evidence of compliance with this order. Pursuant to section 6AAA of the Sentencing Act, I declare that had the company not pleaded guilty to charges 1, 2 and 3, I would have imposed fines totalling $2 million. Had Mr Nagy not pleaded guilty to charges 4 and 5, I would have imposed fines totalling $145,000.